One of the many big problems in the post office prosecutions was that in England and Wales, as a matter of law, computers and computer systems are presumed to be working properly and reliable unless the contrary is proved. So what I thought I would do is just explain how that came about and how that rule really disadvantaged the sub-postmasters and sub-postmistresses, not just generally, but also because of certain egregious behaviour by the post office and their lawyers. And I will unusually be criticising at least one lawyer here for very good reasons. So first of all, what is a presumption? Well, in law, both civil and criminal, sometimes to save time and for expediency, so people don't have to prove every single point of a case, and they're not spending 90% of the time just proving background points. We have certain presumptions where we say, right, here's the starting point. You don't need to evidence this. This is just what we're going to presume. And we have rebuttable and irrebuttable presumptions. An irrebuttable presumption is, a child under 16 cannot give consent. That's an irrebuttable presumption. Doesn't matter. You can argue all you want about whether, as a matter of fact, somebody is clever enough, smart enough, what we call Gillick competent to give consent. Doesn't matter. It's irrebuttable. That's always the case as far as the law is concerned. And that's a matter of law. It can't be challenged. An rebuttable presumption is one where we start from a certain position, but we say it is open for people to prove the contrary. So one example, it used to be that children between the ages of 10 and 14 were deemed to be doli incapax. In other words, incapable of committing a crime because they didn't have the mental resources to know whether what they were doing was right or wrong. And that was the starting position. And actually, it put a burden on the prosecution to actually prove that the child, basically he's a wrong un and he knows it. That's gone now. It's now the presumption is any child over the age of 10 can commit a crime and knows what they are doing. But some very old common law presumptions, or a presumption, is what we call the presumption of regularity. And that started out, one aspect of that is any official act done is deemed to have been done in accordance with all relevant rules and that the person who did the act was duly authorised and qualified to do so. So say, for instance, there's a prosecution about a breach of a planning regulation or planning condition. The planning condition will be on a piece of paper that's signed by, the town clerk or some official at the council. And, to get those conditions, there's a procedure. You have to have meetings, subcommittee meetings, public consultations, consider applications, responses, all that sort of thing, before you even get that far. But the starting position in a prosecution is, we're going to assume that's right. Now, it is open to the defence to say, no, we say that's wrong, but you'd have to specifically say what. We say that one of the meetings wasn't quorum and therefore they couldn't have passed this, or they didn't use this particular correct procedure. Then the burden goes back on the Crown to sort of go, okay, well, here's the minutes from the council meeting, and yes, they did have a proper vote, so go away. Similarly with business records and business acts, all acts carried out, official acts of businesses, are deemed to have been done properly and, if necessary, in the correct order, if that's a factor. So say, for instance, and again, this can be civil or criminal, there's an embezzlement trial and somebody's saying, we were authorised to do this. Well, there's a board minute here saying you weren't. It's like, so we're going to say the board minute said you weren't authorised to do this. They could say, well, no, that meeting wasn't in accordance with the Articles of Association of the company. They didn't give the correct notice. They didn't, they weren't quorate. The chairperson didn't declare an interest, something like that. And then it becomes for the Crown to go, right, again, we've gone off, we've got the minutes, we've got some statements from the directors, and they say, no, this is all kosher. And there's also mechanical devices, or contraptions as they sometimes say, which I quite like. Mechanical contraptions, basically, if they were in good working order, they're presumed to have been in good working order at any relevant time. So that can be things like breathalyzers, speedometers, but also, weighing scales, for example. Say trading standards come round and, do somebody for, selling underweight or something like that, They say, well, what's the evidence? Well, we went in and we weighed all these sausages and it wasn't quite a pound of sausages. Unless you can say, but we know that you dropped those scales, or those scales weren't accurate, and, those scales are deemed to have been working properly and accurate. Just reminds me of that porridge thing now, doesn't it? He's the butcher of Beaconsfield. What did he do? Fiddled about on his sausages. So that's the general idea. Now, when computers came along, computers were just deemed to be, mechanical devices. So the same rule applied. We're going to assume that this computer is working properly. They're a lot simpler back in the day, weren't they? However, by the 80s, people were starting to say, well, two things here. First of all, computers are spitting out quite complex reports. They're not just doing simple returning values anymore. They're producing quite complex information. And if this was a statement from anybody else, this printout, we'd be saying it's hearsay. So if it was like a book of accounts, we'd be saying, get the accountant in to say, yeah, I added all that up and I wrote that down and those are my accounts. Or get the secretary to come in and say, yes, I remember typing that letter when, the director told me to. So I said, isn't this just hearsay? But also, more importantly, people have actually got some experience with computers by then. And we're basically going, they're rubbish. They're really unreliable. Section 69 of PACE was enacted, which said that before any evidence produced by a computer can be admitted into evidence, then the prosecution must prove that all the relevant time the computer was working properly and there's no concerns about it. So it put the onus on the prosecution to prove that the computer evidence was actually accurate. And that carried on till 1999. But in the interim, the Law Commission, which is a body that looks at legislation and sees if it can be improved, it's like a non-partisan organisation. It's not trying to sort of argue the law one way or the other. It's just trying to say, well, what's the law trying to achieve? Does this legislation actually do that? And they said, well, look, things are getting a bit more complex now. I mean, if it was just something like somebody was just, doing a spreadsheet on one PC, then it was relatively simple. Get the IT guy to say, yeah, that PC is working and that software is installed correctly, and that was probably enough. But now with these big complicated systems, it's who do you get to prove it? Do you get the guy who fitted the terminal to prove that it was all wired up correctly? Do you get the people who developed the software? Back at the main software player? Do you get the people who implemented the software? Do you get the people who service the computers? Do you have to get evidence from all of those people to say every element in that chain is correct? So the Law Commission said this is just too complicated now, it's too burdensome. We should do something about it. The result of doing something about it was in the Criminal Justice and Youth Evidence Act, Youth Justice Act, 1999. They just repealed Section 69 of PACE. It just vanished. They didn't replace it with anything else. They just repealed it, and they said, basically, the aim is that it just goes back to the old common law position, which is unless proven to the contrary. This machine was working and everything it spits out you can rely on. So it becomes on the defence to challenge this. And like I say, you can't just do a blanket challenge. You have to, point to a specific reason. But you get this disclosure and secondary disclosure idea. So what the defence can do is that they can say, we think there is a problem with this aspect of the software. And it's for you, basically we're challenging this now. So we want disclosure of anything that shows this. And they would be entitled to, bearing in mind, what the test is, may assist the defence, may undermine the prosecution. Said we want to see all these error logs and things. Because, then that would come back in and it'd be like, well, now this is looking dodgy. The burden shifts back on the prosecution to show that this didn't change things. However, what actually happened was when they were doing these disclosure requests. Now, at some stage, so some of the guys at Fujitsu were just denying they're going, our system's absolutely perfect and there's nothing wrong with it. But in one particular case, the expert on the prosecution side, he just wrote and said, yeah, there's quite a few bugs on this system. Here's some bugs that have been reported. Here's some error logs. And the barrister for the prosecution, when he saw that draft witness statement, he said, you need to take that out because that will just basically completely undermine our case. The defence will just go, well, there you go then. How can you rely on this computer evidence? So he took it out of the statement. And the statement that actually went in implied there were no problems with the system whatsoever. So, what's a jury going to think? I mean, just admitting evidence isn't saying that, it is reliable. It's for the jury to put what weight on it if they want. They can theoretically say, we don't care what you think about whether it's accurate or reliable. We don't think it is. But is any jury going to do that in the absence of any evidence to the contrary? So that's a big issue. Now, the barrister has said, with hindsight, that was wrong to do and I shouldn't have done it. But there's quite a few issues here. First of all, that's a blatant breach of the disclosure obligations and the defence of, well, I don't know computers. So as far as I was concerned, I didn't realise how serious that was, so I said, take it out. Well, make your mind up, mate. If you're not the expert on computers, it's not for you to judge whether that evidence is relevant or not. But also, it just completely undermines, the whole purpose of disclosure, which is, you've got to release this information. And also, arguably, that first statement, the draft statement, should go in as part of disclosure. Because you can do that with experts. You can say, I don't just want to see the final report, I want to see all the drafts and see, and if something's changed, I can then say why. Now, they might have a really good reason. Yeah, this was my first draft of the report. It's full of typos and bad grammar. That's why I changed it. Or it could be, yeah, I put that information in then. However, when I checked or thought about it further, actually that's not quite accurate, so I removed it. It's not uncommon for witness statements to go through several drafts. But this is another issue here, is witness statements being drafted by lawyers. And they're not supposed to. And I'll be covering this because I know people want to know about this. Yeah, the courts have made very strong commentary about witness statements being drafted by lawyers, and especially in corporate type cases where the corporate in-house legal department will just draft everybody's statement, because the whole point is, with the witness statement, it's got to be in the witness's own words, and it's got to be information that either they know personally, or if they want to refer to information that isn't in that, they haven't found out personally, they've got to explain how they found it out, so people can test the reliability of this and go, well, you're saying you heard that from this person, let's hear from this person to see what they know. So that's the issue. So in summary, big problem for the sub-postmasters was the law says this computer system is working properly unless you can prove otherwise. The only way of proving otherwise was to get the error logs, which they should have been able to get through normal disclosure. But the post office basically just breached all their disclosure rules, which I think is something that is going to come up in the inquiry. Ironically, they're already in trouble in the inquiry for not doing the proper disclosure within the inquiry. It's great, that, isn't it? Yes, one of the aspects that we wish to criticise and look at is whether or not you failed in your disclosure obligations, which you have now done in front of me as well. I mean, that's really helping. That's not the way to perhaps conduct yourself in an inquiry. But there you go. As always, hope you found that vaguely useful, vaguely interesting, hopefully vaguely accurate. If you did, please consider clicking, liking, sharing, subscribing, all that sort of thing.